Thank you all for joining us today as we are privy to a robust and insightful academic discussion about the United States Constitution. I am A. Kenyatta Greer, Senior Director of Communication at Emory University School of Law. I am joined today by three of my esteemed colleagues. I'd like to introduce them to you and then turn the event over to our moderator to get the program going. But first, I'll invite you to submit questions in the Q&A function throughout this discussion, and we will address them as we get to that portion. So let's begin with these introductions. First, we have with us today Professor Darren Hutchinson, who is the Emory University School of Law inaugural John Lewis Chair for Civil Rights and Social Justice. At Emory Law, Hutchinson serves as the faculty director of the Emory University Center for Civil Rights and Social Justice. Civil rights and social justice are the central foci of Hutchinson's research, teaching, administrative work, and community engagement. His research crosses many academic disciplines, including political science, history, and social psychology. Hutchinson also examines a broad range of legal doctrines in social justice matters, including equality law, criminal justice reform, LGBTQA rights, anti-racism, and poverty. Hutchinson earned a JD from Yale Law School and a BA from the University of Pennsylvania. Following law school, he was a litigation associate at the New York City office of Cleary, Gottlieb, Steen, and Hamilton. He also served as law clerk to the late Honorable Mary Johnson Lowe, U.S. District Court for the Southern District of New York. We also have with us today Alexander Sasha Volokh, who is a professor at Emory University School of Law, where he's been a member of the faculty since 2009. His interests include law and economics, administrative law and the regulatory process, antitrust, privatization, corrections, and legal history. He teaches administrative law, constitutional law, law and economics of antitrust. Volokh earned his BS from UCLA and did his JD and PhD in economics from Harvard University. He clerked for Judge Alex Kozinski of the Ninth Circuit and for Supreme Court Justices Sandra Day O'Connor and Samuel Alito. Before coming to Emory, he was a visiting associate professor at Georgetown University Law Center and a visiting assistant professor at University of Houston Law Center. And then finally today, we have with us Dr. Ed Lee III, who is a senior director for Emory College of Arts and Sciences, with an emphasis on organizational communication and enhanced collaboration. On and off campus, Lee is a highly sought after trainer and facilitator whose work focuses on communications to improve the workplace and other communities. Additionally, Lee has been the senior director of the Alben W. Barkley Forum for Debate, Deliberation, and Dialogue, which houses Emory's nationally acclaimed debate team and its cutting-edge dialogue programs. Lee is a relentless advocate for public debate and dialogue. He's a national media commentator for U.S. presidential debates and the use of arguments in public discourse. He has a doctorate in higher education management from the University of Georgia's Institute for Higher Education, a master's degree in communication studies from the University of Alabama, and he is currently studying the interconnections between religion, justice, and peace building at Emory University's Candler School of Theology. Dr. Lee, I turn the program over to you until today's discussion is complete.
Thank you for inviting me to participate in this event. I'm deeply excited to be here with Professor Hutchinson and Professor Volokh. As I was thinking about this conversation, I was thinking about how the Constitution was informed by people who disagreed about how we were going to become a more perfect union, while they were very much committed to the disagreement accomplishing a shared why. And that commitment to debate and dialogue is really what we are here to honor today with this event in this moment. We are honoring the way in which the tensions with how we see the world will allow us to personally grow and allow for our organizations to become better. My job here is the easy one. I get to ask questions and create an environment where Professor Hutchinson and Professor Volokh can share and engage the brilliant ideas that they have to offer with us about the way in which the Constitution can be defined as originalism or as a living document. I will pose a question to them and provide some space for the other to react, sharing and engaging of ideas. And so the first question is to both. I'm interested in your brief definitions in order to get us started of originalism and a living constitution. What are some working definitions you would like for us to use as our conversation unfolds?
I'll take a stab at it first. First, I want to thank you for moderating the discussion and to Kenyatta Greer for organizing it. Looking at it, and I would say that there are different varieties, but I'm going to sort of pull them down into the threads. But if you look at originalism, the idea behind it is that when you apply the Constitution, you should look to see what the intent of the framers was, and then you follow that intent to today's problems. Over time, we've seen intent of the framers switch to intent of the ratifiers with respect to people who ratified the Constitution originally and then the amendments. And if you go beyond that, the intent of the framers for amendments would be Congress. So there are different varieties. Another variety focuses on the original understanding or meaning of the terminology in the Constitution at the time it was written. And so that sums up the different practices of originalism. On the other side, I would say non-originalism, or a brand of non-originalism, as you called it, is living constitutionalism. It too starts with history, but it's also concerned with evolutionary ideas in terms of justice, ideas informed by scientific knowledge, and also knowledge informed by the social sciences. So whereas originalists would kind of limit their frame of reference to the historical, non-originalists would consider modern developments and innovations as well.
Professor Volokh, what would you like to add?
Yeah, I think I basically endorse what Professor Hutchinson was saying. What I want to stress is original versus living. Scalia famously said the Constitution is dead, dead, dead. And what he meant was, I think, a very intuitive idea that in interpreting any document, and it could be the Constitution, it could be a statute like the Civil Rights Act that was written in 1964. In interpreting a document, you look to what it meant on the day that it was enacted. And it had a meaning on the day that it was enacted, and that meaning is fixed. It's baked in the pie on that day. And so whatever materials you use to interpret the document, it's materials that had to have existed at the moment of enactment. And I think and that's the sense in which we say original. It just means that it's a static process that takes as given the materials that existed on the day of enactment. And then living says that there exist later materials up to the present day, which are going to be relevant. And in that sense, originalism, just like living constitutionalism, are not just one method, but they're whole families of methods, and people can disagree with each other a lot on what it means to be originalist versus what it means to be living constitutionalism. As an example, Professor Hutchinson started out defining originalism as a focus on the original intent of the framers or of the ratifiers. I, for instance, think that intent should be irrelevant. I don't care what the original ratifiers or framers thought. That's in their head. I only care about the original meaning of words as a sophisticated, educated observer would have understood them as part of the language at the time of enactment. And early originalists, I'll say original originalists, really focused on original intent. And that kind of fell out of fashion among academic originalists for the same reason that a lot of people reject intent in interpreting statutes. And they went to original public meaning, which is essentially the same as textualism when you're interpreting statutes, that all we care about is let's look at the words and let's look at what the words meant in that context. And again, you just look at the meaning of the words at that moment. And then living constitutionalism is going to say, you look at other things that happened after enactment. Could be social movements, it could be changes in social attitudes, it could be changes in the meaning of words, or it could be what would work best today to solve modern problems.
One of the things that the drafters, the original ratifiers of the Constitution, wrestled with was how do they create an enduring document that has some sustainability, if you will, over time? And I'm curious if you think one of these interpretations better animates or honors that spirit of having an enduring document.
So I would say that the way that the document endures, under an originalist framework, the way the document endures is in a number of ways. The most obvious way is that there is a potential for amendment. There's the Article 5 of the Constitution says, here's how you amend. Now, amendment is difficult and it hasn't been done very often, but we do, after all, have 27 amendments right now. So it has been done, and some of those amendments are incredibly important. The Bill of Rights, the Civil War amendments, those are the most important ones, but all of our amendments play a role. So that's number one. They said, we have a document, but here's how you amend it. Another way is that when you're writing a document, you can choose whether to have very specific terms or very vague and general terms. So, one example is that you have to be 35 to be president. Well, 35 to be president, that means precisely the same thing now as it meant in 1787. There's no two ways about it. And I mean, you could say, oh, well, 35 is the new 40 or something, but I don't think anyone really accepts that as a method of interpretation. So there are certain things that they are how they are. Same with the Electoral College. A lot of people hate the Electoral College, but it is what it is, and it's very precisely defined. On the other hand, there are phrases like searches need to be reasonable in the Fourth Amendment. And what does that mean? And the framers of the Fourth Amendment chose to use this language, which, in my view, reasonable means reasonable at the time of the search, which could mean in 2025. And in determining whether a search is reasonable, you are entitled to consider what the modern technology is. And so I think that in choosing to use, in many cases, very broad and general language, that allows for that interpretation to change. And then I think the final thing is, as Chief Justice Marshall said in the early Republic, that we have to remember it is a constitution we are expounding, and just understand that there are ways of interpreting a constitution that might be different than interpreting statutes, and you have to understand that not everything is spelled out, and there might be certain things which are vague, and it could be that long-standing interpretations kind of get fixed by practice. So I think there are a number of ways that even under an originalist understanding, that the Constitution has ongoing flexibility.
Professor Hutchinson, what are your thoughts around this notion of the Constitution as an enduring document and the way in which we can honor that spirit of it?
Okay, yeah. So at this point, I actually do want to put a caveat out there. So we can talk about originalism, non-originalism, and constitutional interpretation in two ways. One would be sort of a theoretical concepts. How do you read any document? What should go into the meaning that you apply to that document today that was written a long time ago? And those debates can occur in so many different contexts that have nothing to do with judging. So we can have a philosophical discussion of that. People have discussions of that in religion with respect to religious texts. So it's not unique to law in a sense. But when we're talking about the actual legal practice, and within legal practice, I'm including judging, things are slightly different. Judging occurs, especially when we're talking about federal courts, where this issue comes up the most, occurs in a political context. Federal judges are appointed through a highly politicized process, the most heavily engaged political process in the United States. That is federal elections for presidents and senators. So to treat these concepts as completely philosophical or abstract, I think, is to portray the issue artificially. Now, within that context, there is a lot of agreement. I agree with Professor Volokh that Chief Justice Marshall, I think, very early on, described the document itself as not being perfect, in the sense that it can apply to every moment or anticipate every situation that would emerge over time. And so there's a degree of flexibility that has to apply there. I also actually agree with the notion that you can be an originalist and think about today's situation. So the hypo of determining what's a reasonable search, reasonable being determined by conditions today, that actually puts very little room between or separating originalists and non-originalists. I think they would both look at that, or at least originalists who are open to that idea. That would be a central drive in them interpreting the Constitution. And in many respects, you see kind of a back and forth. I don't think if you look at a history of any particular justice, would see one always practicing, like literally adhering 100% to what they define as originalism or non-originalism. So there's some flexibility around the terms. I think that our system inevitably will be a mixture of both. All right, so I don't think we'll get one side will be the way the Constitution endures. Just from the example that we've been discussing, originalism combines elements of non-originalism, and non-originalism has always looked to history, but there's been a renewed effort to think about the historical meaning, heavily contested historical meaning, and what that means when we apply it today. And I think that might be one of the deepest drawbacks of pure originalism, sort of taking this philosophical idea and placing it into law. When we talk about original meaning, there's still this sense that there was this common understanding that everyone had, but especially at the time when the Constitution was being amended, say, let's look at Reconstruction, those meanings were highly contested. So to emerge from that with one viewpoint, I think it's difficult to accomplish. You'd have to silence a lot of different voices that were being heard at the time for the first time in U.S. history with respect to adding input to the Constitution. So I would say that we're stuck with both versions, and I don't think it's an unworkable system to have both, because there's enough of a look to history and in some respects, the ability to look to modern needs within both.
Professor Hutchinson, I appreciate you asking us to also think about the way in which the law interacts with our lived experiences on the day-to-day and the legal practices and the way in which judging works. And you started to speak to this, but I'm hoping you can articulate a little bit more about what are some of the dangers of an attempt to adjudicate with a pure originalist interpretation, that someone who wants to judge with that as a foundational premise. What would be some concerns that you would think we should have about that?
All right, so let me just first, before I give those concerns, just say this is either with original intent of the framers or ratifiers, authors, etc., and with original understanding at the time. If you only wanted to adhere to that, right, then you have to be breathlessly comfortable constitutionalizing bigotry and very violent subjugation of the past. So, for example, the people who authored, if we're going with original intent, the people who authored the Constitution with ratifiers, the people who ratified it, they were not chosen through anything resembling a fair process. In fact, that process relied upon the exclusion of non-whites, enslavement of blacks, the exclusion of women from civil society altogether, and denial of political power to poor people. So when we look back to those terms, all right, and actually beyond the terms saying it's what people understood at the time, we are ratifying biases and oppression of the past and encoding them in how we interpret the Constitution today, including the very portions of the Constitution that were meant to respond to these types of inequalities of the past. So I think that is probably the biggest danger, is that you're constitutionalizing inequality. It's built in because that is the past that we have. And so those issues, particularly on issues of equality and justice, I believe is a place where we really need to have that conversation.
Professor Volokh, you mentioned sort of amending the Constitution as one of the ways that's built into an originalist interpretation. I can imagine that would be one of the things that would be brought up as a response to what Professor Hutchinson identified. I'm curious, are there other things that come to mind as you're
Yeah, so like I think when you talk about what the framers did, there's one aspect is the framers many of the framers had horrible values, and many of them were slave owners. Like, I think we can respect Jefferson for a number of things, but we also have to not respect Jefferson for a number of things, in particular being a slave owner, like many like many other Virginians or anyone who came from the South. But um, some of those things they did put into the Constitution, and others were just their attitudes that did not make their way into the Constitution. So, for instance, I think that the original Constitution was certainly permissive of slavery and had certain parts in it that served a function of perpetuating slavery. For example, fugitive slave clause. And then there were other things like the Three-Fifths Compromise, which increased the power in the Electoral College of Southern slaveholding states, and so on. Now, to the extent that the original Constitution facilitated slavery, that was the Constitution at the time. And to that extent, it was a wicked Constitution. So, I mean, it's one thing to say what the Constitution means and another to say whether it deserves to be followed. But if you think the Constitution deserved to be followed, then yeah, it was to that extent a wicked Constitution. We fought a big war and amended the Constitution. So at least that is no longer actually active in the Constitution. But there are other things say, consider the Dred Scott decision from the 1850s. The Dred Scott decision had a lot of parts in it, but the most widely known part of Dred Scott is where the court considered whether Black people could be citizens of the United States. And certainly Black people were citizens of certain states and not of others, and you had free Blacks and so on. But Chief Justice Taney at the time, he said, no, there's no way they could be, because look at the attitudes of the founders. I'm simplifying, but paraphrasing, but basically says, look at the attitudes of the founders. They were so virulently racist that they would never be able to imagine that a Black person could ever be a citizen of the United States. Surely citizen can't refer to Black people, and therefore not. All right. And I have heard people say that, you see, Dred Scott is an indictment of originalism, because you see what happens when you look at what the framers thought. But I say Dred Scott, to my mind, is the most non-originalist opinion, because if you look at the text of the Constitution, there's absolutely nothing there about whether Black people can be citizens. And so I think it is absolutely a mistake to rely on attitudes. I think attitudes of framers are irrelevant, because all I care about is the meaning of text, and there was nothing in the text that addressed that. So I think that on purely original public meaning grounds, Dred Scott was a horrible opinion that did not even it's not even that it was trying to do originalism but did it badly. It just was not even an effort to look at original public meaning. So I think that there are many constitutional questions where, even though the text may have been written by an unrepresentative set of people who did not have good democratic credentials and who themselves were racist, but those attitudes are not in the text, and to the extent that they were in the text, many of those were removed by later amendments. So I think that the idea that originalism weds you to retrograde social views because you're wedded to these dead white males. I think that is right as to certain theories of how you do originalism, but I don't think it's right as to original public meaning originalism, which I think is the dominant academic type of originalism today.
Can I just respond briefly? The way you opened that response to me, and I agree with a lot of what you said, was that if you want to follow the Constitution versus if you want to disagree with attitudes. I think that's a false dichotomy, because I didn't limit my response completely to thinking about original intent. It did shift over to original public meaning. And if you, let's say, surveyed the people across the United States who had the power to influence public meaning at that time, when the 14th Amendment was ratified, you'd be hard pressed to come up with a majority who thought that equality at that time meant racial integration, right? That it meant that Blacks could vote, all right? So even if we're going with original meaning, not the wicked people who had slaves, because I think that's more of a scarecrow argument. If you go with original attitudes of the population, which gives us this thing called meaning, it's hard to divorce that from what society is thinking at that particular time. Even that is a process, and that's really what I wanted to focus on. That itself is a process of ratifying viewpoints that were suppressed historically because of power imbalances. So, looking back to say, hey, originally people did not think that equality applied to X, Y, and Z. Who are the people who were involved in making that historical definition of what equality meant? It's not a democratic process.
So I'm gonna add, when you look at the meaning of words, sometimes you find implications in words which are surprising and which even would not have been which would have been a surprise to the enactors. So on one thing, like for example, does the 14th Amendment secure or does it prevent discrimination in voting rights? I think quite plausibly no. That's why the 15th Amendment is good. And we did have the 15th Amendment shortly afterwards. And so I think that, that's quite plausibly right. But now here's a question. What does the fourth, let's say the Equal Protection Clause? It doesn't say that it says the government can't deny people equal protection of the laws. It doesn't say based on race. It doesn't say or not say sex. It doesn't say what exactly it covers. It doesn't say whether it means integration or separate but equal. A lot of stuff it doesn't say. But it's certainly not limited. And so I think that equal protection, the guarantee of equal protection in principle could invalidate any sort of denial of equality, not just based on race, but I think that to say that equal protection protects gay people, or equal protection protects, prevents discrimination based on disability, or age, or non-citizen status, and so on. I think that all of that is potentially in the Equal Protection Clause, even if everyone adopting it would have disagreed, because they chose to use general words that protected equal protection with no limitation. And so we have to decide how we determine what that means. But I mean, I think that a guarantee of equal protection means that every differential treatment of anybody on any basis has to be justified by a good enough reason. And what means a good enough reason, that's something that we can continue to discuss today. But in my view, that is perfectly consistent with originalism, because there's nothing there that violates the original meaning of the specific words that are in there. I would say similarly, like I've said, that the original public meaning approach to the Constitution is essentially the same as the textual approach to statutes. So let's take a very recent opinion from, I think, 2020, Bostock, which interpreted the Civil Rights Act of 1964 and the prohibition of sex discrimination in employment, and asked whether it prohibits discrimination against gay and trans people. I think we can all agree that in 1964, most people did not have good views of gay and trans people. And if you had polled them on what does it mean to prohibit discrimination on account of sex, they would say, yeah, of course we didn't mean gay and trans people, you crazy. But nonetheless, the words they use were to prohibit discrimination on account of sex. And if I fire someone because, let's say it's a man and who married a man, and then I say, well, if you had been a woman who married a man, I would say congratulations. But because you're a man marrying a man, I say you're fired. So I treat you differently because you're a woman versus because you're a man. And so like that is just straight up technically sex discrimination. And so even though no one thought that the Civil Rights Act of 1964 protected that sort of thing, but they chose to use words that were very general. And I think that an originalist approach, in this case a textualist approach, would just say let's look at the original meaning of those words and not the attitudes and not the expected application, but just the original meaning of the words. And so I think that Bostock was a perfectly good originalist opinion that came to surprising results. And so for the same reason, I think Obergefell, which protects gay marriage, I think, is plausibly a good originalist interpretation of the Equal Protection Clause, even though no one thought that it would have protected gay marriage at that time.
I think, I would ask that you parse out what you mean by original meaning, because even in 1964, if you say what is sex discrimination, would the meaning then, all right, in 1964, I'm not even like asking about people's attitudes about gays and lesbians, but if you asked what sex discrimination meant, you won't find many legal authorities or voters, lawmakers, etc., who thought anything about gays and lesbians in that meaning. Now, I agree with you. We shouldn't be limited to that, but it starts to move away, I believe, from traditional concepts of what originalism is. And my evidence for that is the justice who claims to be or who is seen as the biggest adherent to originalism disagrees with everything you just said. Like, the sex discrimination fits within that, the sexual orientation discrimination fits within that, the disability discrimination fits within that. He said it doesn't, right? And there are a lot of opinions by the justices who say they're originalists, validating those concerns. So in the same exercise where we did sexual orientation fitting in with sex discrimination, you could do the same thing with abortion. All right, so that abortion bans subjugate women economically and in terms of depriving them of use of their bodies. But the originals on the court would say, nope, that's not even what the attitudes or meaning of the terminology was then. And pregnancy is not gender, so you can't say that this is something that's hurting women as a class. But there's tons of literature exploring in the same way that sex and sex discrimination are similar, that discusses how pregnancy discrimination and restraints on what women can do with their bodies during a pregnancy is related to sexism as well. But that is just not something that most practicing originalists would say. So perhaps maybe that's an indication that the folks on the court who identify with the originalist camp, maybe they're doing something different. And while I see some academic originalists who embrace kind of a more flexibility that you are, it's not traditionally been the type of analysis you see coming from even academic originalists.
Give you the final word on this section, Professor Volokh, and then we'll shift a little bit.
Yeah, sure. No, I agree that many practicing originalists, including ones on the court, take a different view. And I think this is a problem of originalism becoming popular, is that everyone says they're an originalist, but not everyone means the same thing. And so what I don't want us to do is to say, let's look at who is the most vocal originalist. And let's say we focus on Justice Thomas, for example, because he is definitely a very vocal originalist and maybe the one, maybe the most like vocal about being consistent on that on the court. We might agree or disagree with everything he does, but I don't think that the people who are most vocal about it necessarily have to be the ones who define what originalism means. And just by way of analogy, I would say lots of people claim to be Christian. I'm Jewish, so I don't really have a dog in this fight, but I know that a lot of people claim to be Christian, and they come to very, very different interpretations of what that means. And many of the ones who most vocally claim to be very textual, about the true meaning of Christianity, you don't have to agree with them. But it doesn't matter how much you disagree with them. That doesn't mean that Christianity is false, because everyone is able to say, no, they're just simply wrong about like their method. I agree in principle with their method, but they just came to the wrong result. And it is open to all of us to still argue within that same method that, no, they just came to the wrong result. And this is the proper way of doing it. So I would not, when we're debating originalism, about whether originalism is true, I think it's open to all of us to say that originalism is right, and here is how to do it right. And everyone on the court is doing it wrong, but that doesn't make originalism wrong. That just means they're bad practitioners of originalism.
I want us to take a little time to explore the notion of the living Constitution, and specifically one of the criticisms that gets lobbed against it, That one that it grants far too much power to judges to the extent that it turns them into legislators. And I'm curious if you think that interpretation is a fair criticism of that interpretive notion of living constitution.
No. So let me tell you why. So I understand the critique. So if we don't have a foundation that we can agree upon to interpret the meaning of the Constitution, then any sitting justice or single judge, if we're talking about a trial court, can just determine that meaning, and that opens the door to all types of politics. Even under the most, I would say, postmodern view of interpreting text and non-originalism, no, that's an overstatement even for those. Judging is bound by so many things: tradition, the terms of a case as it comes to the court. Unlike Congress, the court can't just sit down and decide we're going to take up this issue today and decide whether or not same-sex marriage should exist in the country. They can only decide cases or controversies. Yes, what they say about those cases or controversies have a lot of meaning. They're binding as law in many ways. So that's the overlap they have with the legislature. But they can't sit down and operate in the same fashion. So I think people who make those arguments, and they make them on both sides, right? So you see non-originalists say that originalists have done this and vice versa. I think they're overstating the point. But to take it in a more moderate view, to say that allowing judges to do more than simply look at original intent or meaning, that it opens the door for a lot of power. I would say yes, it does, but I don't think that that's only a one-sided proposition. Judging itself is a very powerful process because of the issues that are being debated in that setting. And so either side, both sides, I think, need guideposts to get them to conclusions that are consistent with a democracy, bolstering the values of a democracy, and inclusion and diversity. And I don't think simply saying originalism is a way of doing that, and consider it this way. Originalism can become a very politicized process. One thing I did admire about Scalia is the amount of times he wrote about judges being political. The only thing I didn't like about that is him not turning it in that lens towards the originalism side. It was only originalism that opened, non-originalism that opened that window. But it's there also with originalism itself, at least as practiced by certain folks on the bench and political movements in society that promote it. So if your viewpoints and perspectives ideologically align with values, say from the 19th century, early 19th century, then originalism could be a very comfortable place for you to operate. You can use it as a rhetorical tool to say that I am consistent with the past and I am unbiased, while at the same time you are promoting an agenda of ideas that were perpetuated inequality. On the other hand, a non-originalist can come clean and just say, here, this is what we're doing. So I just don't think that one side of this coin is any more of a process for opening the door to ideology than the other. Judges are incredibly smart, I'll put it that way. Law is sufficiently ambiguous that it gives a lot of discretion to judges to interpret that meaning. So whether or not you call yourself an originalist or not, there's room for different outcomes using each methodology. Just as Professor Volokh said, I can be an originalist and support same-sex marriage. I agree with that. If you look at some of the non-originalist opinions recently, they're using originalism to back more progressive agendas. I would say affirmative action is one of those. I've done research myself on that issue. The attitudes of many people at the time, and certainly the framers of the 14th Amendment, they backed race consciousness to some extent in order to do good for society, to remedy the conditions of slavery and discrimination. If you look at the abolitionists who were informing the members of Congress who drafted the 14th Amendment, they certainly wanted um, broader economic and racial justice than simply "you shall not discriminate." But originalists today, at least those a narrow body of originalists who kind of define what it means in terms of judging, they would completely disagree with that. If you read the affirmative action cases of the Roberts Court, for example, they don't resemble in any way the debates among members of Congress about the meaning of equality and racial justice, and certainly not the meaning of the political movement that generated the Reconstruction Amendments.
Yeah, so
yes.
I'm sorry. I think there's a lot of common ground between me and Professor Hutchinson on this. Like, I think that there are a lot of good agreement. Sorry, there are a lot of good arguments about originalism versus living constitutionalism. I just don't really think that I don't really accept that the argument that originalism is in practice more constraining of judges than living constitution. I just don't think that that's really proven as an argument. That is, I think that's the hope. Yeah, the hope is sure. Like if you could find that particular words meant one particular determinate thing in the founding period, then yeah, we would go with that, and that would be our one thing. But I mean, if they really were that determinate, then I think most non-originalists would also say we should go with clear text. So I think that on all of the important, controversial, hot button issues, not only is there disagreement on policy in society, but there's also disagreement about what people thought that the words meant at the time of the founding. And so a lot of the areas where the Supreme Court has written supposedly originalist opinions, there are people, I haven't necessarily looked into all of this, but people I respect that say, no, actually, the historical evidence is much more ambiguous, or sometimes even that the historical evidence actually really goes the other way. And so I think that, like Professor Hutchinson said, law is vague enough and has enough leeway, and also the historical evidence is rich enough that if you have people who are conservatives or liberals today, people often will look at the evidence and will find, oh yes, clearly that goes in my direction. And good lawyers are able to make arguments like that. So I think that well, and then conversely, if you're a non-originalist, that's only a family of arguments. I want to know, what is your specific theory about how to interpret the Constitution? And some theories might be super determinate, and others are not. So I don't know that any one theory of constitutional interpretation is any more determinate than any other, and so therefore I'm not really sure what theory gives more power to judges.
Yeah. I have a specific question for you, Professor Volokh. A lot of your scholarship and research, you are wrestling with First Amendment and property rights. And one of the things that we're all wrestling with are technological changes that's expanding access to information, some would say misinformation and disinformation, challenging and stressing the ways in which we think about accessibility and the utility of and the ways in which the First Amendment can protect us. How would an originalist interpretation help us to think about the First Amendment, particularly in the context of the technological revolutions that we're experiencing with information access?
I got to say, the First Amendment doctrine is one of my very favorite parts of constitutional doctrine, because we have such a strong First Amendment that protects, it protects so much more than pretty much anywhere in the world. And also, I think by historical standards, it's stronger now than it has been at any other time in this country's history. And I love that. there's not an originalist word in any of that doctrine. Like that is one of the most non-originalist parts of doctrine, and I love it. And I recently represented strip clubs here in Atlanta, and we were challenging a Georgia tax on strip clubs on First Amendment grounds. And sadly, we lost that case. But I argued it twice in the Georgia Supreme Court, and I asked the U.S. Supreme Court to hear the case after we lost, and unfortunately, they said no. But I was scared as hell that they would say, you know, this First Amendment case law of ours is really not originalist. Let's rethink it from the ground up and really look at originalists. And I was really scared that they would do that because there's no way that I would win if they ever tried doing that. So I wanted to tell them, if you want to do that, please wait until the next case to do it and just decide my case under existing doctrine, okay? And property rights are a very similar thing. For the last 100 years, we've had a doctrine that the government owes you money if it takes your property, but there are lots of ways of taking property with depriving you of your property rights without outright taking it. Like, what if the government just regulates your property to such an extent that you can't do anything with it? And so for the last 100 years, there's been this regulatory takings doctrine where it can be basically a taking just by virtue of being very strong regulation, even though the government hasn't taken title to your property. That too is a kind of made-up theory. As far as I know, it doesn't really have much originalist backing, and I love it. And I think we should have more of it, but I'm not going to rely on originalism for that. So this kind of goes to Professor Hutchinson's point that our doctrine and our debates, they're like none of it is purely originalist. I mean, even Justice Thomas and other people who profess strong originalist sympathies, they have really never shown much of an interest in rethinking regulatory takings law or First Amendment law from the ground up on an originalist basis. But to get back to your original question, is how do we make sense of technological change? I think, for example, in one sense, technological change is easy, which is that there are just a lot of more ways of speaking than there used to be, and there are a lot of more ways of using the press than there used to be. So now there's the internet and social media. It's still speech. So pretty much the doctrine has taken the position that you can have new ways of speaking and it doesn't make a difference. We're certainly not bound to technologies that existed in 1791 when the First Amendment was enacted. All these different technologies, they don't change the fact that they're speech. And so our doctrine pretty much should be unchanged. And so if you think that there are specific harms from social media, well, the doctrine gives you ways of addressing harms, and so the way that plays out might change over time. But like a technological change in itself doesn't necessarily make a difference. And kind of in the same way that property rights, now we understand we can have a property right in a lot of intangibles. And so if the government seized my patent, or if the government seized my web domain, I could say, you seized my web domain and that was worth $1 million and I need compensation for $1 million. So the fact that we have unusual forms of property that would have been unimaginable, I mean, it's not that important, because there's just speech still exists, property still exists. It just takes different forms, but the text doesn't address that, and that's okay.
I have a specific question for you, Professor Hutchinson, and I think it may harken back to part of our conversation that we were having earlier. And I'm particularly interested in your thoughts, considering you're one of our leading experts and scholars on the civil rights, particularly the Equal Protection Clause. One of the concerns that could be articulated, or has been, is that a living constitution interpretive stance allows for us to see modern events and apply the Constitution in ahistorical ways. That we take ways of seeing events, moments, stances of rights, notions of violence that when the Constitution was written, they did not see or think about things in those particular ways, and that it applies a set of modern values in an ahistorical way, and that creates its own problematic stance. Maybe it allows for judges to create rights that were not ensconced in legislation. Maybe it moves us too quickly in a direction that doesn't account for the values of the larger country. I'm curious, what are sort of your thoughts around that notion of the living constitution and the ways in which we think about civil rights at this moment, and it particularly being ahistorical?
Right. Thanks for the question. I mean, I think during the debate, Professor Volokh and I both have kind of expressed that there's a lot of room for connecting the past with today. So I guess I reject that if you are doing a non-originalist approach, it's necessarily divorced from history. So, for example, just on the same-sex marriage question, just looking at a Burgerfell, a case that held that from an equal protection perspective and a due process perspective, denying same-sex couples the opportunity to be legally married violates the Constitution. You could say, and critics of that opinion have said, if you look at the dissents in particular, that this is so removed from the Constitution. It is simply an application of today's values to the past. But if you dig more deeply, right, dig more deeply and have a more nuanced appreciation of history, you can see how equality itself was, one interpretation of it was that it was meant to end like group-based historical oppression of people. So the classic example of that would be racial discrimination, but it's not only racial discrimination, it's also sex discrimination. So rather than looking at, I like to tell my students that there's one way of interpreting the Constitution where everything is this little fixed, isolated point in time. So if you're looking at the historical meaning of what equal protection meant, it's about racial discrimination rather than what are the values that were underlying those concepts. And it's kind of hard to, with what we know about sexual orientation today, from science, from sociology, to kind of ignore that there are some oppressive elements or dimensions to denying same-sex marriage. It's privileging certain classes over others. And the idea that social privilege should not be a basis for law is not a new thing, right? So it's existed throughout our history. It may not have been perfectly applied. It was not very inclusive historically, but over time, we have been committed to that value, and groups have contested the meaning of the Constitution in order to make it a more inclusive document. So to say that we are informed by today does not erase it from the past. And I think the people who do good non-originalism, there's like an overlap with the people who are doing kind of a modified version of originalism that Professor Volokh talked about today. There is room for discussing these things as historical concepts. And the same discussion goes on outside of equal protection. It's also in substantive due process where we're talking about fundamental rights, right? Even if there wasn't something called a fundamental right to abortion, does it connect to other rights that people have accepted over time or historically? That's the kind of conversation that non-originalists have in that setting. So I think the problem is if we say that things today have no connection to the past, it's usually an overstatement. All right, it's an overstatement. There is some connection. All right, just as the sense that posting things on the internet is speech, even though the internet didn't exist when the Constitution was ratified. All right, so we need to figure out what equality means in today's terms. The new group comes up with a problem. We don't say that the framers did not think about that, so the Constitution is of no value to you. We try to figure out how to apply that. So I fundamentally reject the separation of evolutionary thinking about what equal protection means to say that that has nothing to do with history, that it's newfangled, new creation, new age constitutionalism, unbridled from tradition.
I have one final question for each of you. And I'm thinking about folks like myself who are not lawyers, not legal scholars. Uh, why should the majority of us care about this debate, care about this conversation, about the way in which judges interpret the conversation, and how does that impact all of our lives?
Well, I'm going to say one reason to care is because, well, one reason not to care is that Professor Hutchinson and I, as you see, we have a number of points of agreement, and so like on certain things. Let's say he and I probably agree on the gay marriage decision, for instance. And so what that means is that certainly other people disagree. There are originalists who disagree with me, certainly. But then you can say, well, then the problem is not with originalism as such, but with particular ways of practicing it and so on. I think that the difference between these approaches can certainly be overstated. Nonetheless, there are differences. And like Professor Hutchinson mentioned a couple times abortion. We didn't have time to get into abortion. I am fairly radically pro-choice as a political position, but I do think the Supreme Court got it right in overruling Roe v. Wade. So I think Dobbs is right, even though that's not my personal politics. And I think that most likely an originalist approach is going to get you there. And so that's one place where there would be particular differences. And so just because I think not everywhere is there necessarily a difference, but there will be a difference. And so I think that it does make sense to care about how judges say that they are going to interpret the Constitution. And then another thing is just as citizens. I think even if we came to the same conclusion all the time, I think the theory matters. Maybe not everyone cares about theory, but I think that this is my bias as an academic speaking. I think it's important not only to get the right result, but to have the right reasons for it. And so even if we agreed on the result but disagreed on the reasons, it's still fun to argue about the reasons. And it's not just fun, but it's a fun that gets to our identity as Americans and American citizens and invested in the American project and the founding and the Constitution. And so I think that these are relevant discussions to have, even if it didn't make a difference in practice. But I think that in many areas it will make a difference in practice.
Professor Hutchinson.
Yeah, so actually, when I first heard the question, I was thinking, well, the majority of people don't need to know this. That's because I am my reaction was, as an academic, there's been a proliferation of scholarship on the meaning of non-originalism and originalism. There are so many iterations of originalism now that even some of the biggest non-originalists, like Jack Balkin, is now apparently an originalist. So, because he's a living originalist. So there's so much there that I don't think the public would ever have time to get into if we're talking about the nuances of the academic debate. Certainly, people should care about how the Constitution is interpreted as citizens. It's so important for anything that's valuable to our existence as individuals, as groups, as a nation. The Constitution speaks to that somewhere, right? If not explicitly in the values that are expressed in the document itself. And so many people don't make that connection. And I think that the people who are supposedly educating the public on the political process, and by that I'm not talking about teachers and professors, I'm talking about politicians themselves, don't really do a good job of stressing the importance of judicial interpretation in an honest way to the debates that we have in society. So things as important as marriage, as abortion, as equal protection concerns regarding racial justice, gender, disability, all of those things have constitutional dimensions to them And if you are want to be an informed citizen, or to think about the values that your government is bound by, then you certainly should have an interest in constitutional interpretation. I would say that, just to close my part of the discussion, is just reading Frederick Douglass. So I just spent the entire summer doing a lot of research on abolitionists, and in particular Black abolitionists and their influence on abolitionism and the 13th, 14th, and 15th Amendments. And they had a lot to say about the Constitution. And I already knew this, but if going into it, so Frederick Douglass said, interpreted the Constitution as a pro-slavery document. Later, as he saw the implications of politics and started becoming more politically involved, he said the Constitution was not a pro-slavery document. All right, two fundamentally different approaches. And law professors, so I was reading all of these articles on that, they're focusing on the meaning of originalism as constitutional interpretation, but he did that for a practical purpose. Right? And that's where I think laypersons come in. Like, they are more interested in outcomes, but those outcomes depend on constitutional interpretation. So he reinterpreted the Constitution to promote abolition. So to say that being anti-slavery, that's not a new thing, all right? Even though maybe the founders did not agree on that, it's not new. It's consistent with the values that are written in the document itself. That was a move, I think, that was very important, and that could inform people today trying to see where they connect to this. There's enough room in the values that are stated to apply them to any number of situations today that are really important. And I think that's really, for me, the most important thing to come out of this discussion. All right, both sides look to history. The question is, how does that view of history apply today? Does it actually reflect the values of the past, or is it more just a political choice?
Before handing the proceedings back over to Kenyatta Greer, I want to thank Professor Hutchinson, Professor Volokh for an amazing conversation. When I think about the kinds of work we want to do on a college campus and the role that we can and should be playing in facilitating engagement about and across our political and ideological differences, these are the kinds of exchanges that I hope will be the model for how we move forward, both on our campuses and beyond. I'm truly thankful for you allowing me to be a part of this and to be engaged with you this afternoon. And on behalf of Emory University, thank you for sharing your brilliance with all of us. Kenyatta Greer, I will hand the proceedings back over to you.
Thank you, Ed. I echo his sentiments, and I thank you, Ed, for joining us and moderating so brilliantly. I'd like to thank Dr. Carol Henderson, Senior Advisor to the Provost, for her collaboration and support in the planning of this event. And then I hope you all will join us tomorrow evening for the final part of this series, during which our scholars will converse about the power of the purse and the checks and balances. Good afternoon. Thank you.